Double C.
20 past 8, cloudy, some patches of frost and fog around the region today with a slight chance of a shower. Tops around the 13-degree mark across Canberra and Queanbeyan and around 11, 12 degrees across the rest of the region. Now, we talked yesterday about the fact that former NRL star Jarryd Hayne had his appeal against his sexual assault charges upheld. The 4 counts of sexual assault were quashed. But the question has been asked by one academic, what price are we prepared to pay for the pursuit of justice, and when does prosecution become a persecution? Terry Goldsworthy is an Associate Professor of Criminal Justice at Bond University and a former Queensland Detective Inspector. Terry, good morning.
Yeah, good morning.
It's an interesting question because some would say the pursuit of justice should continue until justice is served, but sometimes that's not necessarily possible.
Well, that's correct. And if you've, have a look through the appeal judgment, it is interesting to read it. I mean, for your listeners, the appeal went before 3 judges. One judge dismissed all 3 grounds. One judge upheld all 3 grounds, and one judge upheld 2 grounds. 2 of the judges who upheld the appeal both made comment about whether he should face a 4th trial. In particular, one of them said quite specifically that she was of the view, in the circumstances of the history of the matter, to put the applicant on trial for 4th time would not be the interest of interest of justice. The other judge made comment that there is good reason for there not to be a 4th trial, but ultimately it's a decision for the DPP. So, I mean, the appellant court has flagged this as an issue, whether he should go back. Normally they just order a retrial and off it goes to the DPP. They make no real observation about these issues. But obviously this is a unique issue now. We've had 3 trials, one of them a hung trial, 2 finding of guilt, and 2 successful appeals against those findings of guilt. So it's really an unusual case.
And I guess the other issue here is, and there's been a lot of discussion around how sexual assault cases are dealt with by the courts. And look, I know the legal fraternity, and I agree to this too, is the principles behind our justice system can't be abandoned just because there is one certain type of crime as opposed to another. But generally, these type of cases are he said, she said. There's only so much evidence to go around. I mean, how do you it would be almost, well, I would think it unlikely that this will go to a 4th trial.
Yeah, I would think that would be the case. I mean, in terms of, sexual assault matters, there was an interesting paper put out by the Bureau of Crime Statistics and Research in New South Wales about a month ago. And it looked at the attrition rate of sexual assaults. And there is an attrition rate as it goes through the criminal justice system, as there is with other charges of other nature. But, when you look at the matters that do get to court in terms of adult sexual assaults, the conviction rate is about 38%. So I think we have this impression that hardly anyone gets convicted.
Yeah.
The finding of guilt rate is 38% for those matters that do go to court in terms of a trial, etc. So, I mean, when we talk about the public interest, what are we talking about here? We're talking about things such as Hayne would be likely to be past his parole period by the time the matter goes to trial again. So it would be highly unlikely he will face a jail term, given the fact that he's already eligible for parole before it goes to trial. You then have what we call the resources of the state, and this is where you have an individual who's charged has the resources of the state against them. So it doesn't realistically cost the state anything to run another trial. It will cost the individual, and that's problematic when you're talking about now 6 legal proceedings. 6 years, it'll be 7 years on by the time it goes to a new trial. So is that becoming, an unreasonable expectation, and is it, an unfair process is the question I guess we're asking.
The question that I ask, though, is at what point do we decide that it's acceptable for a potentially guilty person to go free because of the process?
Yeah, look, I mean, that's certainly one side of the argument. There's 2 sides of it. Potentially guilty, but under our system is presumed innocent.
Yeah.
And that's a key concept that is often thrown out, in particular when we're talking about the emotive issue of sexual assaults. And we've currently got a federal commission looking at the legal system responses to sexual assaults. And I am concerned by some of the, rhetoric and submissions we've seen where people are saying that, you should have the right to silence, that we should reduce it to the balance of probabilities in terms of the burden of proof, etc. I think we need to be very careful about how we tinker with our justice system because we are perhaps not getting the results that we think we should get. Our justice system works well in the main. It does have glitches. I mean, I teach in the area of miscarriages of justice. There are times when we get it wrong. But just because you're not getting a result that you think you should get doesn't mean that you should change the system to make it easier to get the result you think you should get.
Because you've almost got to make a decision or make a judgment that one type of crime is worse than another type of crime in the eyes of the law if you're going to make those changes, don't you?
Well, that's right. I mean, the submissions put in, to my understanding, were that it should only be in terms of sexual assault matters that we should make these changes. And underpinning the justice system are three principles. One, that we're treated uniformly, that there's equality before the law, and there's certainty to outcome. Now, if you just make one set of rules for one particular offence category, then you look at someone who does a robbery and shoots someone, they get the benefit of reasonable doubt, not having to speak to the police. If you commit a sexual offence, you don't. I don't know how that is actually equitable in any shape or form.
Yeah, absolutely. Terry, interesting insights. I really appreciate your time this morning.
Thanks, Stephen.
Terry Goldsworthy, Associate Professor of Criminal Justice at Bond University. He's also a former Queensland Detective Inspector. Let's have a look at what's happening in North America this morning.
On 2CC Breakfast with Stephen.